freedom of speech, freedom of religion. These types of liberties are considered negative rights because they prevent the state from infringing on those particular rights. In addition, you have what are known as positive rights, which have to do with the rights to things. For example, rights to housing, rights to education, food, these types of things. And when we look at it in the UK context, we see that the rights, particularly the negative rights, are statutory in the sense that they're not constitutionally guaranteed, because they can be given, and then also they can be taken away by statute, because there's no actual written constitution. There is a written constitution, but it's written in many different places in the British context. So it's important in a written constitution for Scotland that these rights be written down and constitutionally held, rather than being statutorily held, so that they will be more solid in law than they are under the British context. Because as you have seen, the British government wants to get Great Britain out of the declaration, the European Declaration of Human Rights. I don't know what the British government is not able to do now that they would be able to if they withdrew from the Human Rights Treaty, but it's quite worrying. And I think that it's whatever way the Great England goes, I think once Scotland becomes independent, it's extremely important that they begin to have they established constitutionally these basic rights. But the problem is that many of these rights, as we're seeing with, for example, in the United States, there is the Roe versus Wade, the decision which upheld the right to have an abortion in 1971, that is on the verge of being overturned. This would mean, and so what was considered a constitutional right is very likely going to be overturned by this summer if the draft case that was leaked is anything to go by. And that would mean that the right to an abortion was based on the right to privacy. And the right to privacy was established in the Griswold versus Connecticut of, I believe, 1964, because the Bill of Rights in the United States that was adopted in 1791 does not mention the right to privacy. The right to privacy is derived from the Fourth Amendment, but there's no categorical right in the Bill of Rights to privacy. And so it was enunciated, it was sort of the right to privacy was kind of drawn out of the Fourth Amendment in the Griswold decision, which allowed for which legalized contraception, and then also that notion of privacy was used in the Roe versus Wade decision of 1971, and this has been eroded over time, is on the verge of being overturned, so that women will no longer in many states, and if Roe is overturned, this would mean it would return to the states. So this is one example of the way in which the rights although they are supposedly constitutionally protected, we see that in the case of the Roe versus Wade decision, that it's very fragile, and so that there needs to be very effective means to make sure that these rights are upheld over time and not subject to either a Supreme Court, which hold on, one sec. But not subject. So I'm just getting this site up. Okay, but what's also important is in order for rights to be effective, you have to be able to have redress. If you are discriminated against, if your right to privacy has been violated, if your right to free speech or freedom of religion has been violated, these rights mean nothing unless there is a way to redress if they are violated. And that's one of the things I see, particularly in the United States, as even if people's freedom of speech is violated or freedom of religion, it's extremely difficult to get redress. This is also often the case for sexual discrimination as well, particularly in the workplace, where the Supreme Court has made it much more difficult for women to sue. For example, there was a case with Walmart a few years ago where there was a class action suit of women suing Walmart because they had not been advanced in their jobs, and all the men had. And so, but then the Supreme Court ruled that they could not bring a class action suit against Walmart. So that's one of the things that's made it much more difficult for actual redress of these violations of rights to be effective. And so one of the things that's really important when there is these rights drafted is that they're put into effect the means to actually enforce these rights, and so that anybody and also that have equal access to the legal system. And as it currently stands, I believe in Scotland and in the UK and many other places, you have to, even if you even want to begin to file suit against someone for whatever discrimination or what have you, you have to get a lawyer, and that's very expensive. And most people don't have the money to hire a lawyer to have these to pursue these cases. So another thing that needs to be done is to make effective, inexpensive remedies possible for when people's individual rights are violated. It's a similar case with the positive rights. As I mentioned, while the objects of having the right to housing, the right to education, the right to health care, all of these things are extremely laudable, but the problem, the difficulty becomes if there isn't sufficient money for example, housing or healthcare or what have you. What is the right still guaranteed, or what are the means by which these rights can be upheld? As I said, I'm speaking in the terms of positive rights. And that's where for example, there could be there would be the constitutional obligation for the government to work towards these ends of full employment, of full housing, housing for everyone, et cetera, while it there also needs to be means to have redress as well. So what I'm going to do now is share my screen, and I want to go through some of the ones that I wrote in the constitutional draft that I have set up. So hold on just one sec. Okay, so here is the I can make, certainly I can make this available. I can put it up. I will put up the link on the chat so that people can have access to this draft. But I wanted to go through slowly go through the article on individual rights, liberties, and obligations that I put forward as a possible rights. One thing I have not done is I have not defined gender. I did this before the obvious controversy that's arisen over that. That is something that would very much need to be worked on and specified clearly in a Bill of Rights of what sex and gender, and working those out, probably through a citizens commission or something that can work these out work these issues out outside of the political realm. But I just wanted to go through a few of the notions that I put into that I've stipulated as putting into practice. So first of all, that all of the equity of rights, all citizens and residents of Scotland, regardless of their status, shall be equally treated and protected under the CSL, or the corpus of Scottish law. Provision shall be made to assure sex parity in opportunity and pay at all levels of the public and private sector. The Scottish state is secular and pluralist and shall not favor nor disfavor any religion and shall work towards the appeasement of religion sectarian conflict in all forms. All religious and religiously owned institutions shall be subject to civil law, regulation, and taxation. And so I believe, in my view, I think that given the long history in Scotland of sectarianism, it's very important that the Scottish state set an example and not be tied to any one particular religion or another. As we know, the UK is, the Queen is the head of the Anglican Church, and the Protestant Catholic divide has been a very, obviously contentious issue, to say the least, over the years. And so I think it would be important for the Scottish state to be secular in the sense that it does not profess any particular religion. That does not infringe at all on the liberty of worship, that anybody can, believe or disbelieve whatever religion they feel that they wish, but that the state itself does not profess any favoritism towards any faith or religion, and that it remains strictly neutral involving religious affairs. Also, number 3, social equity being the basis and essence of this constitution and Scottish polity. No aristocratic nor noble privileges, titles and or estates historically granted by any monarchy shall be recognized by the Scottish state for any purposes. No law which perpetuates social castes, including primogeniture law, shall be recognized, promulgated, or applied. All human beings shall be treated equally under the law. I also believe, I also view that the way that the British state has been set up with the Queen, with the monarchy, with the lords, this social hierarchy that's very much baked into the governing structure and the social hierarchy in general. And I think that Scotland, has a different view towards the class structure, which I think is more egalitarian. But I think that, and in my view, the UK government can do what they want to with their lords that happen to be named in Scotland, but that Scotland, the Scottish government has no business recognizing any of these titles, and that there should not be this kind of feudal hierarchy baked into the governing system as it is in the UK. I think Scotland should get as far away from that as possible. Okay, then the fundamental individual liberties: freedom of speech, press, speech, writing, publication, and expression of opinion; freedom of thought, conscience, and of religious practice, including not to believe or participate in any religion; autonomy of all persons over their bodies, included but not limited to the right of terminate pregnancy and euthanasia. All human beings have the right to marry and found a family in accordance with their beliefs and sexual orientation. All human beings have the right to peacefully assemble and form associations. No law or government policy shall abridge the right of every person to freely form or join a union in their place of work, collectively bargain with their employer, to strike without state opposition, and the corpus of Scottish law shall penalize any infringement of this right. Every person has the right to conditions of work which are fair, healthy, and which respect the dignity of the person. A living wage and guaranteed minimum income shall be established by the corpus of Scottish law to assure that no person shall live in poverty, which shall be continuously updated according to economic criteria established by law. So I think that this would go very far towards the idea of having actual labor law in a constitution is something that I don't know of every constitution, but not every. Certainly, the United States Constitution does not have this, and there's no workers' rights in the United States Constitution. After all, it was written when slavery was in existence. So maybe obviously workers' rights were very far from their minds, but I think it would be very important to guarantee democracy in the workplace, in guaranteeing that everyone has the right to form a union and collectively bargain with their employee. The right to privacy in his or her personal affairs, family life, home, and correspondence, consistent with technological advancement. Provision shall be made in the corpus of Scottish law to safeguard personal data information and preserve privacy and security in communications and transaction conducted through electronic media with the highest level of security and encryption possible. No restriction shall be made other than by a modification of the corpus of Scottish law, and much respond to a competing a social need, be limited to duration and proportionate to this purpose. The right to hold private property, to the enjoyment of their property, the obligation of the Scottish government to take action for a healthful environment, including clean air and water, and a climate hospitable to life and agriculture. Everyone shall have access to government information, and all government reports shall be established upon completion. Every person shall have the right to physical safety. All arms and weapons for those who are not on duty police and military personnel are banned, with very limited exceptions granted for single-shot rifles, very different from the U.S. Constitution of the Second Amendment, which guarantees the right to bear arms. I think that Scotland would do very well in not having the amount of arms that the United States does, and thus avoiding the everyday slaughter that the United States undergoes. Also, the corpus, the Scottish law shall not criminalize drug and alcohol use by individuals for personal use, which shall be treated uniquely within the sphere of public health. So that's, the decriminalization of drugs for personal use. It's a big subject. Obviously, there'll be differing views on that, but I think that taking it out, at least personal use, out of the criminal domain and placing it in the health domain would be a positive step forward. Then very quickly, then I'll wrap up. The positive rights: the Scottish government shall be constitutionally bound to progressively assure for all, regardless of income, that every person has the right to adequate housing. Every person shall be entitled to universal basic income. Every person shall have sufficient state-funded physical and mental health care. Every person shall have access to a state-funded education, which allows them to reach their potential. And then I have about a Scottish citizens card, which allows for voting, which would allow for having a Scottish citizen's bank account and other, which can also include different information, but basically having a biometric citizens card, which would be very useful for providing benefits, for being able to vote, and many other advantages that we can look to countries like Estonia and others that have made great advances in digital technology that Scotland could just adopt from the beginning. So I'll leave it at that for going over the rights, and of course I'll make it the text available of what I've worked on. But I did want to go over a couple things that regarding the Alex Salmon case and the Craig Murray case, which brought out some slightly problematic things in the criminal justice system, which I think should be rectified upon Scotland being independent and constructing a judiciary. And I think that one of the breakdown in the separation of powers that occurred, I believe that the Lord Advocate being both on a member of the government and the chief prosecutor is a problem, and that should be avoided. I think that given that what I view, at least from what I've seen of that case, also the fact that the Alex Salmon was charged not things under the law so much, but in a change of policy that was enacted by the Scottish government. And I think that people have to be charged under what is the law and not what is a change in. And then finally, the role of the Crown Office as very much an adjunct of the British state. And I think Scotland needs to, upon independence, Scotland needs to create a much more independent judiciary that is much more focused on justice for the people. So that concludes my remarks, and I'll be happy to answer any questions you may have, and I will certainly make the text of my the Constitution that I've drafted available for everyone to view. So thank you very much for listening.
How can you make the Constitution dynamic?
That's a good question, and I think that I'm glad the sound is clear. I think that it needs. I believe that the Constitution needs to be updatable on a regular basis, and contrary to the way that the United States Constitution has been amended over the years, where they tack on these amendments to it, I think it's important that the Constitution be able to be updated on a fairly regular basis, and also that citizens can make suggestions to it as well. And I think that could be done that can be done kind of electronically. It can be like kind of almost like updating your software, but I think it's and I haven't worked out the exact mechanisms for that. And I think that with technology and with people being able to make suggestions of how, the Constitution can be and then people can vote on, there's means to have people vote on the constitutional amendments without changing making the wording clearer, these types of things. But I think it could be something that could be constantly updatable, just like kind of software, it could be. And so but I think it's very important because, for example, with the U.S. Constitution, it's pretty much stuck in time, and it hasn't been changed at all, for many years. There's been, amendments tacked on it, but the fundamental structure is completely outdated. And I think that it's very important for, there be means provided, means whereby the Constitution can be updated on a consistent basis. There can be different mechanisms for that. It can be initiated by individuals or by citizens, so I think that, again, just making it constantly updatable within certain parameters without changing without violating fundamental rights, I think is very doable.
And thank you for that.
Much as questions to you all as it is to the definitive commonweal position on any of these things. And the reason for that is quite interesting. So I'll just give you a quick update about what Commonweal is focusing on this year. And that is, it's not really a manifesto because we're a think tank, not a party, a political party, but it's about what does an independent Scotland look like? We talk a lot about a referendum, and what we're actually fighting for all the time is to have a referendum or to get independence. But actually what we really need is a vision of what that independent Scotland looks like, because that's what will shift the vote as much as anything else. So one of the things that we're working on extensively this year is all of the different aspects of an independent Scotland. So this is post-referendum. This isn't a manifesto for the referendum. This is about what does an independent Scotland actually look like? What does it feel like to live in it? And that's really relevant to the conversation that we're having tonight. So there are the constitutional issues, and like Mark, I've been involved with Mike Russell's working group to create an interim constitution. And that's one that, so that when people are voting in a referendum or whatever, they know what will happen on the day of independence. That isn't actually the constitution that Scotland will end up with. And Commonweal firmly believes that that should be established post-independence by a citizens' assembly and various working groups and what have you. I think it's really interesting if we look into the historic context. We only got a franchise in the UK, or what is now the UK, because the powers that be were worried about a revolution. And they felt that if they gave us a little bit of power, that would avoid a revolution. Whereas in France, where they had a revolution, there are certain basic rights that are inherently embedded in their constitution. I think it's quite interesting, and I was talking with somebody the other day about the idea of the social contract, which I think is a phrase that most of us have heard. In the US, they took the example of the French Constitution to create the American Constitution. But basically, they missed out a lot of the bits that they felt might be problematical. And so the social contract in the US is very different from the social contract in France. It's very different from the social contract in the UK, which I would say was probably broken by Mrs. Thatcher. Because any time where a society feels that there's no need, or it doesn't feel a responsibility anymore to support the poor and the less advantaged, then basically that contract has been broken. And right now we're in a situation, I would say, Mark, both in the US and in the UK, where our governments are claiming the right to ignore the poor. They're like, let's just get on with life as normal. And that's really problematical for me. I think it's very problematical for Scotland in terms of how we frame our constitution going forward. I would say that the constitution is one thing, and we have to be careful not to put policy into our constitution. I'll give you some examples. Maybe something that I was protesting at Holyrood a week ago was about the right to food, or the right to good food. And the right to good food in international law is already embedded in the Universal Declaration of Human Rights. And our law within Scotland, because our government chooses, actually includes all of those international treaties. So when we eventually get to the bit where we're writing our constitution, I think it's really important that we focus on some of the things that were highlighted in Mark's document, but we also have to be careful that we understand the necessity to agree with international treaties. One of the other ones that applies to us here in Scotland is the Convention on the Rights of the Child. Well, we've got a difference in Scotland from England. So I just wanted to set off in those. I also want to talk a little bit about immigration and refugees and citizenship, because I think those are really important things for us to be talking about. You know, do we all understand the difference between immigration or immigrants and refugees? Watching some of the stuff that's being carried in the media recently, I'm not convinced that we do. And I'm also not convinced that there is one path going forward on any of this. The rights of refugees were initially laid out in the Geneva Convention, and you know, there are international treaties that are concerned about that, and we need to make sure that what we're saying about refugees is not misleading in terms of other immigration. But you know, when you look at what happened at Kenmore Street in Glasgow, and then more recently in Edinburgh, I think it was Nicholson Square, where citizens and local residents come out onto the streets to prevent people being deported by this dreadful Home Office's officers. It gives us this impression that Scotland is really pro-migration, and that we talk all the time about, yeah, if you want to be Scottish, just move here. And this is something that we're talking about quite a lot, because there will be a chapter of this work that we're doing that will specifically relate to immigration and citizenship. And I'm not convinced that everybody in Scotland is as welcoming to refugees as we think. And I'm also very aware of the difference between economic migrants and refugees. So through international law, we have an obligation to provide a safe haven for refugees who arrive here, and to help them arrive here if they need a place of safety. And that is very correct. I don't think many of us would disagree with that. The thing is, though, that are we creating a sort of a cultural shift by removing people from their place, their own culture, on the assumption that all refugees will always stay here? I would far rather see us working to improve the situation at home so they could return safely to their own homes. And if you talk to refugees, that's what most of them would actually like. Yes, they will make successful lives in Scotland if that's what's necessary. I'll be really interested. I'm not sure if she's still with us. Yes, Farah. Really interested to hear what your circle of acquaintance think of that. I've lived in a lot of other countries, not just in Scotland, which is why I've got a weird accent. And most of the people that I have met on my travels love the country that they grew up in. And if it was safe for them to be so, then they would stay in the countries that they belong to. And so what do we do to help people who are fleeing places where it's not safe? Giving them an immediate safe haven is a really important thing. But should we also be doing more work to help make those places safe for them? And that's something that I'm struggling with a little bit at the moment about, is a safe haven enough? What more needs to be done? And then when it comes to economic migration, you know, because of the clearances and everything else, Scotland's population is way lower than it would naturally be at this stage. So of course, we welcome having new people moving to Scotland, and that's a good thing. But we also have to look at this in the longer term context. We know because of climate that climate migration is going to become a major factor over the next 10 to 20 years. Scotland is extremely well positioned in terms of the climate emergency. And so it will be, you know, a very attractive place for people to come and live. But we're not talking about a few thousands. We're talking about millions of people globally who will need to move from the countries that they currently live in because those countries are no longer safe for human habitation because of climate. And so whatever policies we put in place need to also look at that big climate migration that we're not really seeing yet, but we know that it's coming. So food for thought. I'm not saying that there's a solution on any of these things, but food for thought. And then I'll just move quickly on to talk a little bit about citizenship. In Scotland, we've got one of the most generous electoral mandates in the whole of Europe, and in actual fact, from most countries. The fact that we have now reduced the age to 16 and basically said, if you live here, you get to vote in the local elections and what have you, that's unheard of across most of Europe. The Scandinavian countries are a bit more aligned with us, but the rest of Europe, particularly Italy, is much more restrictive about who gets a vote. My husband's Swiss, that's why I've got a weird last name. And Switzerland is probably one of the most restrictive countries in terms of gaining citizenship and getting the right to vote. Because I'm married to a Swiss, I could apply for citizenship after 5 years of actually living in Switzerland. So we've been married for 20 odd years, but I've only lived there for 1. So I would have to restart that if we were moving back. But if you're not married to a Swiss, the naturalization process of becoming a Swiss citizen is 10 years. And you don't get to vote even as a permanent resident. So you can see that we've got, from the situation we've got in Scotland to the Swiss situation in Switzerland is massively different. It's not that different in other European countries. In France, you have to have permanent residence for 5 years before you can apply for citizenship. And so we are starting to see some very broad acceptance of what we're saying about, oh, anybody can be a citizen. Well, does that mean that anybody can come and vote if they've lived here for a week? Or if they've paid taxes? Or if they have an address? These are all quite discriminatory practices, and in terms of who you would allow or who you would give a vote to, I don't think there's been very much thought about this. We are beginning to see a bit of that now in the discussion about a potential referendum and what that should look like. And I know that lots of people have got very strong ideas about this. I just think we need to talk about it, Paul. It's one thing to say in the local elections, if you live somewhere, you can vote there. But does that mean that if you've lived there for a day, you can vote there? I think I've sort of outlined things. I hope it doesn't sound too awful, because I really don't mean it to be. At least, if even 3 years ago, I was totally in favor of open borders. Everybody should come here. That's, why should we be so privileged and refuse that right to everybody else? But actually, as part of the work that we've been doing and looking at this in more detail, I'm probably more cautious about it now, and I haven't ended up at a final point. So I would really, really love to hear from all of you about your views. And if you don't want to say anything tonight, email me, amanda@common.scot, because this is a big piece of work that we're doing. And it's really important that we hear from everybody. And I see that Farah has already got her hand up, so perhaps we could go straight over to Farah. Sorry, Chair.
Hi, Amanda.
Yes.
So you were asking maybe what my take on refugees and repatriation.
Yes.
Okay, so I used to be an immigration officer.
Right.
My parents came here on a work permit as well, so economic migrants.
Interesting.
Right, so and I've worked in the community, and I'm a second generation. I was born in Glasgow.
Yeah, yeah.
So
I knew that.
Right, so as you can tell from my accent.
Yes.
Right, okay. So I can give you all sides to it. Repatriation, not a fan of, I can tell you myself, because where are the people that come as refugees supposed to go? Right, now this is my take as an immigration officer. Also, my take as having worked in the community, having worked with asylum seekers as an immigration officer, and on the other side, where are they supposed to go, having fled from countries that have been gutted by war, from UK, USA, and NATO?
Hi, that's for sure. So that's the interesting thing. What?
No, yeah, interesting, but just hear me out here. Where are people? Where are they supposed to go? I mean, we're talking way back. You're talking about Kosovo, Serbia, Palestinians, Syrians, Ukrainians actually, and I'm going to put it out there, have been very lucky. They've got a visa straight away, 3-year visa.
Farah, I'm going to say they've not been lucky. They've been white.
No. I'm talking about from an immigration point of view. I'm not talking about the war. I'm talking about the immigration, how lucky they've been in getting.
No, but I honestly believe that there is a lot of racism in that.
No, I'm not talking about the racism. If you just hear me out, Amanda, I'm talking about the how quickly they got the visa. I'm talking about being a former immigration officer.
Yeah.
I still talk to my colleagues. I was an immigration officer for 10 years. And I'm going to give you the differences. I hate war. I hate NATO. Yeah. Right? I'm a CND child.
Good.
80s, in the 80s, while I was in school, I was forever camping, you know, whichever solidarity, socialist, you name it, I was there. But where does it stop?
Yeah. You
cannot repatriate people. Where will they go back to? There's no economy. So my thing is, if the people, the refugees are here, you know, I don't even like the word refugees, but if they're here, New Scots, if they're here in Scotland and we've already got a dwindling population, you know, let them contribute to the economy here. We've already got a dwindling population. We've got a dwindling economy. And the people that come over, they've already got skills. Why aren't we tapping into their skills?
Yeah.
Okay. Now, secondfold, economic migrants. My parents came here when they were 17 and 18, you know, economic migrants, you know. My mother speaks, as I've said before, she's got an accent of like Mary Doll Rabsy Nesbitt. We all know about Rabsy Nesbitt, you know. So economic migrants contribute to the economy, and they always have and they always will. You know, some came over here when they were 17, some came over here later, some came and stayed with a highly skilled migrant program. You know, the economy needs them. Again, with the dwindling population, we can train our own children, our own populations to raise our own workforce and move forward. But when it comes to repatriation of refugees to war-torn countries, I think that's virtually impossible. You know, putting on my Home Office, ex-Home Office hat and what NATO has done. And that's all I'd like to say. If anybody else has got anything else to say, by all means.
That's brilliant. Thanks so much, Farah. It's really interesting, especially a immigration officer experience. Please come and work with us on this policy. I would really like that. We need to have informed people helping with that. The one thing I didn't say, which I should have done, is when people arrive here currently, there's the support available is not good enough. And we've seen that consistently. So the Commonweal view is that is then part of our national care service. You know, we have this thing about community hubs delivering care. That's where support for immigrants and refugees should be held within the care service to make sure that our view of a care service is really there. I see Jeff's got his hand up. Hello.
Hi, how are you doing?
Good.
Good, provocative stuff there. I'd like to be a little bit more provocative and describe an incident that quite astonished me in the 2014 referendum, where I was talking with an old guy. Now being an old guy myself, I kind of think about his input. And what he said was really interesting. He said, look, I'm 75. I don't have much of a future in this country. So I asked my grandkids how they would want me to vote. And so he took his stance from what his grandkids told him, and he voted yes for independence. But the broader question is more about, you know, the enlightenment of bringing 16-year-olds into the franchise. Should that be balanced by knocking out people in their 70s, say, like me, who probably don't have too much of a future you know, they've got less future in the country than the 16-year-olds. Is that a proposition you've ever heard?
That is really interesting. I have never heard anybody suggest that before. I think that given that we all live longer and we still need services, we need to be able to, in our later years, vote, because how else do you ensure that you get the services that you need to survive?
You embed them in the Constitution.
That's really interesting, and I'm talking on the fly here because I've really never heard anybody say that at a certain age your voting rights fall off.
Yeah, maybe it's 80, maybe it's, you know, whatever.
I think it's really interesting. I'm going to take that back to the team and have a really interesting talk about that. We may come back to you, Jeff, for some of your ideas on it. Thank you.
Thank you for that, Jeff, and that question. Marry someone of the same sex, breached his Articles 8, 12, 13, and 14 human rights. The court found in his favour for both his Article 8 right to respect for a private and family life and his Article 12 right to marry. This landmark case resulted in the Gender Recognition Act 2004 being introduced to allow transsexuals to obtain a gender recognition certificate and have the sex on their birth certificate changed. Unfortunately, the GRA also created the current confusion around the difference between sex and gender, deliberately. Although a GRC means transsexuals will be recognised in UK law as the required gender, there are a few important exceptions where someone with a GRC can be treated differently. One is a right of conscience for Church of England clergy who are normally obliged to marry any two eligible people by law. Another is that sporting bodies can prohibit or restrict the participation of transsexuals in sport where it is necessary to ensure either fair competition or the safety of competitors. Interestingly, the third exception is primogeniture. It appears that sex matters after all if there's an inheritance or a title up for grabs. So what does this mean in practice? Well, one of the main purposes of the GRA was to allow transsexuals to marry someone of the same sex, although this has been superseded since same-sex marriage has been legal since 2014. The other is the right to a private life, which covers areas such as confidentiality at work. The current process requires a medical diagnosis of gender dysphoria and for the person to have lived for 2 years as their preferred gender, whatever that means. So where does the Equality Act 2010 come in? The Equality Act consolidated and replaced a number of separate acts tackling discrimination into one piece of legislation. The bedrock of the Equality Act is the 9 protected characteristics, one of which is gender reassignment and one of which is sex, and there are situations where the two come into conflict. The Equality Act provides exceptions where it is lawful to treat people differently because of their legal sex. Men who identify as trans but don't have a GRC don't share the protected characteristic of sex with women, so they can be lawfully excluded from women's single-sex spaces and services in all circumstances because they're the opposite sex. For those who do have a GRC, their legal sex has been changed, and this legal fiction means they do share the protected characteristic of sex with women. However, they can be lawfully excluded from women's single-sex spaces and services on the grounds of the protected characteristic of gender reassignment, but only where it is a proportionate means of achieving a legitimate aim. Last month, the Equality and Human Rights Commission issued updated guidance on the Equality Act sex and gender reassignment exceptions for providers of separate and single-sex services. This makes it very clear that trans people can be lawfully excluded from single-sex spaces where it is a proportionate means of achieving a legitimate aim. regardless of whether they have a GRC. So what qualifies as a proportionate means of achieving a legitimate aim? They say that a legitimate aim could be for reasons of privacy, decency, to prevent trauma, or to ensure health and safety. They also provide a number of examples where excluding all trans people would be lawful, such as single-sex hospital wards, a group counselling session provided for female victims of sexual assault, female-only fitness classes, and separate sex communal changing rooms. That sounds perfectly clear and reasonable, doesn't it? Except for the problem of institutional policy capture by groups such as Stonewall, Equality Network, and Scottish Trans Alliance, who have all misrepresented the law to government, service providers, and policymakers to such an extent that it is referred to by many people as Stonewall law. These lobby groups claim that having the protected characteristic of gender reassignment means trans people must have access to spaces and services set up for people of opposite sex, and to deny them access is unlawful discrimination. This is wrong. Having protection from discrimination on the grounds of one protected characteristic doesn't ride roughshod over the protection given to others with different protected characteristics. Stonewall and others are even campaigning to have the single-sex exemptions in the Equality Act removed from the legislation. One question that never seems to be answered is, if, as these organisations claim, a GRC isn't needed to access single-sex spaces designed for those of the opposite sex, why are they so focused on reforming the GRA so a GRC can be obtained on a self-declaration basis? That's apart from the fact they're wrong about the law as it stands, as the new EHRC guidance makes clear. So how and when did it all go so wrong? After same-sex marriage became legal in 2014, the primary aims of Stonewall had been achieved, in law if not in practice. So what now for the charity? According to their website, in 2015, Stonewall extends remit to become LGBT charity and begins journey to trans inclusion. Except that for many people, including founding members of Stonewall, they didn't extend their remit. They replaced it with an ideology that erases the very concept of same-sex attraction. At the same time, a number of foundations and organisations around the world began pushing the idea of gender identity, focusing particularly on children. These organisations include the Open Society Foundation, the Arcus Foundation, and the Human Rights Campaign. Suddenly, there appeared to be a coordinated effort around the Western world, not only to push this ideology to children, but to change laws and language to fit. Coincidence? Absolutely not. In 2019, journalist James Kirkup came across a report written by the world's largest law firm, Dentons, the Thomson Reuters Foundation, and an organisation called the International Lesbian, Gay, Bisexual, Transgender, Queer, and Intersex Youth and Student Organisation, titled Only Adults? Good Practices in Legal Gender Recognition for Youth. The good practices described in the report include lobbying to change the law so that parents no longer have a say on their child's legal gender. It states, it is recognised that the requirement for parental consent or the consent of a guardian can be restrictive and problematic for minors. So this is a handbook for lobbying groups that want to remove parental consent over significant aspects of children's lives. The report goes on to advise lobby groups to get ahead of the government agenda, as it will be easier to shape legislation if they write it themselves before the government has had time to develop their own. Another tip is to tie your campaign to more popular reform. To quote the report, in Ireland, Denmark, and Norway, changes to the law on legal gender recognition were put through at the same time as other more popular reforms, such as marriage equality legislation. This provided a veil of protection, particularly in Ireland, where marriage equality was strongly supported, but gender identity remained a more difficult issue to win public support for. That's still part of the quote from the document. I find it absolutely chilling that governments around the world are being manipulated to such an extent by powerful lobby groups. Another tip is to avoid excess press coverage and exposure. Ireland features here again, with the admission in Ireland, activists have directly lobbied individual politicians and tried to keep the press coverage to a minimum in order to avoid the issue of misinterpretation by the public. So not only are these groups successfully managing to drive what they know are unpopular policies and laws around the world, they don't want people to know about it. At least we now know why the Scottish Government have embraced the policy of no debate. Thankfully, I think that the point of no return has come and gone in Scotland and the UK as a whole, as the aim of avoiding press coverage has spectacularly failed. I also think this report makes it very clear that transgender ideology is the complete opposite of all other campaigns for equality. Whereas the campaigns for equality, regardless of your race, sex, and sexual orientation, were driven by grassroots movements that gained public support and approval, and eventually resulted in equality in the eyes of the law, this ideology works in a top-down way by changing laws with virtually no public support or scrutiny. The effects on women's rights are very clear. Despite legislation in most Western countries protecting women's sports, there have been a number of cases in the last few years of men being allowed to compete in women's events, from swimming, cycling, weightlifting, even mixed martial arts. Similarly, despite laws protecting the most vulnerable women in society, men are being placed in the women's prison estate, even when they've been convicted of sexual crimes against women. When did women become so expendable that this is seen as okay? In 2014, the Scottish Prison Service published its policy on gender identity and gender reassignment. Written by James Morton of Scottish Trans Alliance, he stated at the time that we strategised that by working intensively with the Scottish Prison Service to support them to include trans women as women on a self-declaration basis within very challenging circumstances, we would be able to ensure that all other public services should be able to do likewise. The Denton's report obviously came in handy with its tips for getting ahead of the government agenda. Rona Hotchkiss, the former governor in the Corrimpton Vale Women's Prison, believes that the very presence of males in the women's estate re-traumatises many women, especially as the majority of them have experienced male violence. Why don't these women matter? Another success story for the lobbyists in Scotland was the passing of the Gender Recognition on Public Boards Act, the Scotland Act 2018. After successful lobbying by Scottish Trans Alliance, again, the Act, which was intended to address historical underrepresentation of women on public boards, included a definition of women that included some men, but excluded some women. This was done without public consultation or full and proper parliamentary debate or scrutiny. The grassroots feminist group For Women Scotland were granted a judicial review, which they initially lost, but won on appeal. The Court of Session ruled that the Scottish Government had exceeded its power by redefining the protected characteristic of sex under the Equality Act, where a woman is defined as a female of any age. A number of legal experts, such as Scottish solicitor advocate Gordon Dangerfield and former president of the Law Society of Scotland, Ian Smart, believe that this ruling shines a light on the Scottish Government's policy of having to be trans-inclusive, which of course means being mixed sex, in order to receive government funding, and also that the Gender Recognition Reform Bill in its current form would be beyond the legislative competence of the Scottish Parliament. We can but hope. This case is just one example of the differences between the two opposing sides in this debate. As you've heard, those pushing for reform are doing so from a position of great influence and power, with apparently unlimited funds. The groups in opposition, such as For Women Scotland, rely entirely on voluntary donations and crowdfunding to fund legal cases, whereas Scottish Trans Alliance, Equality Network, Stonewall Scotland, LGBT Youth Scotland, and Engender all receive significant funding from the Scottish Government, i.e. the taxpayer. It's beyond ironic that critics of groups like For Women Scotland claim, with absolutely no evidence, because there isn't any, that we are funded by right-wing Christian fundamentalists out of the US, when it's actually them being funded by right-wing, white, billionaire Republican men in the US. Transgender ideology is very big business after all, and every major corporation from Disney to Calvin Klein is jumping on the very lucrative bandwagon. Big tech and big pharma are laughing all the way to the bank to the tune of billions every year at the expense of the young and vulnerable. The worst part of this ideology is that it has reached our schools. Children as young as 4 are being taught that they can choose their sex based on what clothes and toys they like. Local authorities across Scotland are changing school toilets to mixed sex. And mixed sex toilets are also included in plans for new primary schools. This breaches the provisions in the School Premises General Requirements and Standards Scotland Regulations 1967, which states that half the sanitary accommodation in schools shall be for boys and the other half for girls. There is no provision for unisex, mixed sex, or gender-neutral facilities. Government guidance for schools, written by the state-funded groups LGBT Youth Scotland and Scottish Trans Alliance, was written without giving any thought to the rights of other children, especially girls. Another grassroots feminist group, Women and Girls in Scotland, conducted a children's rights impact assessment on the guidance, and their findings were horrific. The guidance, which was issued by the Scottish Government and endorsed by a number of charities and organisations who really should know better, was found to be in breach of no fewer than 11 articles of the UN Convention on the Rights of the Child. After the impact assessment was published, the Children and Young People's Commission of Scotland publicly criticised the guidance, and at a meeting on 7th March 2019, government ministers admitted that advice given in the guidance, quote, was not legal, unquote. Despite a promise to withdraw the guidance, this wasn't done until amended guidelines, again written by LGBT Youth Scotland and Scottish Trans Alliance, were published. The new guidance still misrepresents the law on separate and single-sex bases. By now, it shouldn't surprise you to hear that LGBT Youth Scotland and Scottish Trans Alliance also train both public and private entities on equality law. I mentioned earlier that the current GRA requires a medical diagnosis of gender dysphoria and for a person to live for 2 years as the preferred gender. You might be aware that the proposed reforms aim to remove the medical aspect altogether and reduce the time from 2 years to 3 months with a further 3 months for reflection. I know a number of trans people who have been through the current process, and they disagree with the government's view that the process is too long and intrusive. During a long chat with one of my trans friends, he talked about the counselling he received as part of that process. He said he thought many of the questions were extremely odd at the time, but knowing what he knows now, he realises they were a necessary part of the gatekeeping process. If we remove all gatekeeping from the process, it will be abused by bad actors. We all know the lengths predatory men will go to access vulnerable women and children, and anyone who dismisses the fact they will abuse self-ID is at best extremely naive. So if trans people who have been through the current process are as against sex self-ID as women are, who exactly will benefit? I don't think I need to spell that out, do you?
Thank you very much.
Thank you, Carol. I'll take that back.
Okay. Thank you for that, Carol. That was very detailed and informative. Has anybody got any questions for Carol out there? Or anybody got any questions in the room here? I do. Oh, we have a question. Hello, would you like to introduce yourself? Get over here. Does that work?
Thank you. Yeah, hi, I'm Serena Arif. I have a question for Carol.
Yes.
I've seen many people on social media saying women are actually quite positive about GRA reform. What did the polls actually say about that?
Thanks for that question. I think all the polls that I've seen anyway show that as a whole, women are supportive of people presenting and being who they want. I don't know anyone who thinks otherwise. When it gets down to the matter of men who go through no visible or apparent changes, you know, no hormonal treatment, no surgery, nothing, being able to access spaces that vulnerable women and girls and also boys will be in, then the numbers change significantly. And from what I've seen, it's upwards of 80% in every poll.
80.
Yeah.
Wow.
Against.
Yeah. Okay. Wow. Significant, isn't it?
Very, very much so. I mean, I grew up in the 70s and 80s, you know, David Bowie, Grace Jones, Annie Lennox, you know, Kiss with all their makeup, Marilyn, Boy George, you know, of course, everyone can be who they want to be, but you cannot choose what you are, only who you are. I mean, a lot of what's involved in trans ideology as it's been pushed now is what we used to call personality.
Yeah.
You know? And, you know, far from the claim that, you know, they're smashing down the gender binary and everything, I actually think it's the reverse. They're reifying the regressive sexist stereotypes that feminists like myself have been railing against for decades. You know, back in the day, you know, it was girls can do anything, they can be anything, same as boys. Now it's, oh, if you like pink and play with dolls instead of trucks, you're a girl. And here's some drugs to fix your body to match the stereotypes that you lean towards. It's horrific in my view, horrific.
Okay, thank you.
Can I ask a question, please?
Of course.
Brian asked a question.
I'd like to ask if you would like to comment on the fact that some of these bodies have the same people in more than one body and get duplicate funding.
Pardon?
Yes. Absolutely spot on, Brian. I don't know the nitty-gritty details, but yes, it's as few as about half a dozen people sit on multiple boards across these government organizations, having, you know, taking home very nice flat salaries. And they're driving policy, I mean, in Gender, which is supposedly Scotland's official feminist organization, they've admitted that they don't even listen to their own members, never mind the women of Scotland in general. And I think there's a class issue here as well. You know, a lot of the people who sit on these boards and write these policies and whatever, they're very much middle-class professional feminists who will never be affected by the actual impact of these policies. You know, in terms of rape crisis centres, prisons, you know, they are deciding the fate of women and they will never experience that fate themselves. And I think, you know, as I say, the class issue is a very, very important one that needs to be addressed.
Okay. Thank you for that, Carol. Any more questions online or in the room for Carol? If not, we'll pass it back to questions for any of our three speakers. Anybody else got something to ask?
something I'd like to say.
Oh,
Here's David.
It's clear to me, looking at the GRA bill and the limitations of the Scottish Parliament, that their GRA bill will be overturned because the Scottish Government can't possibly have competence over changing definitions in a Westminster piece of legislation. It's a bit like thinking a local council can write a new law itself. It can't. It can only enforce the powers that it's given. And that is exactly what the Scottish Government has now wasted the last 2 years, hundreds of thousands of pounds on a piece of legislation that will, without any doubt, be overturned when it gets to the Court of Session or the Supreme Court, because they don't have the competence to edit Westminster legislation.
There's also another point. There's also another aspect of that the Scottish Government have failed to address, and that is cross-border implications. You know, if our GRA Act is significantly different from the one in England, what are the consequences?
My understanding is they don't have a GRA bill in England.
Well, they do.
They've got the Equality Act.
Oh, they don't have a GRA bill. They have a GRA Gender Recognition Act 2004.
So that was before the Equality Act 2010,
Yes.
which included characteristic recognition for post-trans operative.
No. The Equality Act has one of the 9 protected characteristics is gender reassignment.
Yeah.
And that covers people at all stages of their transition.
Mhm.
And that, to be honest, I think that's the only legislation that's needed, because it rightly protects trans people from discrimination on the grounds of their gender reassignment. But where, you know, the professional, you know, the Stonewall, LGBT, Youth Scotland, etc., get it wrong, that doesn't give them the right to override the protected characteristic of sex. But what it does do is it protects them against discrimination in situations such as employment and housing. And that, as I say, I think that's absolutely right.
I think the one thing that I found extremely worrying about this is, where are people's thoughts about, let's say, a child, because I had researched a little bit about this. My view, that's why I stood for be elected, is I was looking out for parents' rights. Parents' rights to be consulted before schools change whatever they want to change, knock down buildings, remove the library, whatever. Parents should be consulted, because we hold parents legally liable for their children's welfare. Yet the councils are ignoring the parents, bringing in new rules, deciding usually during summer recess to knock down walls and remove toilets without speaking to anybody. So I believe that fundamentally parents should be consulted. And on top of that, they should give their informed consent. And they're not being even consulted, let alone being asked for informed consent. I think that's where things are falling to pieces. Ultimately, I believe parents have their kids' best rights at heart. And I think government should stay out of people's private lives as much as possible, because let's face it, look at the mess they're making. But my concern comes down to not just that. If they go ahead, let's say a child goes through this process and they are put on sex-changing drugs, and then they get to a young adult and they find it was all a terrible mistake, and actually they were just depressed or they were emotionally upset. How do you undo what you've done? The truth is you can't. And there's been cases that went to the High Court and they won and said that no one looked after their rights or treated them properly, and they pushed them down this route, and they liked having all the attention. And that's another thing that they find out with these cases when you start looking into them. Many of these children that are pushed down this route actually have other issues at home. So in fact, what they've welcomed is the fact that medical professionals have welcomed them, supported them, and they felt safe, which they've never felt before as a child because of their bad background. But ultimately later on, they find out that's not what was wrong with them at all. It was probably their parents were abusing them, or there was drugs, or there was violence, or whatever.
Or they were gay.
Or it was their sexuality, who knows? But the bottom line is, and this is what I think most politicians and the Scottish Government would do well to remember this, as a politician, you're meant to look out for the people that are voiceless and the people who are vulnerable.
Yeah.
And I don't think that's happening. And you don't get equality by removing the rights from one group and granting more rights to another. How is that equality? That's not equality. It's quite the opposite of equality, actually. Any form of discrimination is actually discrimination. You know, I support women's rights. One, I was brought up by my mum. So if you want to know what a strong woman is, well, you should meet her, even though she's now in her 70s. She used to knock down walls and move the door in our house because she decided it was in the wrong place. It would be better over there. And you come back from school and there's a hole in the wall. She built things. She slabbed the front garden. She dug the fish pond. She built the rockery. She did it all herself.
But she didn't say she was a man.
No, she's not a man. But she's a very strong-willed woman, right? An independent woman. Let me tell you a little bit when I realised women weren't treated equally. I was about 13, I think, years old, 12 or 13. My mum had a job, right? And she wants to buy a car. She's got her own job, got her own income. She wanted to buy a car. So we went and looked at this car at Appleyard in Edinburgh. I remember it distinctly. A light blue Volkswagen Polo Derby. It's about 3-4 years old. It's quite a lot of money back then, but she could afford it. So she got the details, she could get a loan. Now this would be about 1972, I think. Guess what happened next? The car salesman showed her around the car. Oh yes, it was perfect. She could afford the payments a month. Well, you'll need to bring your husband in to co-sign the loan because obviously the bank won't accept a woman's signature on a loan. I remember that to this day, and that was a long time ago. And I thought, wow, a woman isn't allowed to sign a loan agreement on her own. What, she's a lesser human being? Yes. And unfortunately, there's not enough people that seem to remember that. You know, women are equal. They can do any job they like. So I just want to say, I think it's long overdue that men started speaking up for women's rights. Because I tell you what, most of them seem to be too afraid to say anything. Well, I'm not afraid to say something. Women's rights are men's rights as well. Otherwise, we don't live in an equal world.
You brushed on cases such as Kira Bell, and in Scotland we've got Sinead Watson, although she's not involved in a court case. She's similar to Kira in that she did transition. She took cross-sex hormones, which have caused irreversible changes to her body. She had a double mastectomy, as did Kira. And then she realised, I mean, let's face it, the human brain doesn't fully mature until you're 25. She realised this was not the solution to her problems after all. So she, what they call detransitioned. She went back to living as a woman, but with these irreversible physical changes. She's, you know, most of these young women will now be infertile. But the GRA reform bill in Scotland doesn't mention that. I mean, this talk of, oh, after 3 months you can make a solemn declaration. And it's a criminal offence, apparently, if you don't, you're declaring to live in that gender for the rest of your life. And it's a criminal offence to lie about it. So where do all these thousands of deep transitioners come in? There is no provision in this bill to cover the young men and women who change their minds and realise that actually it wasn't the solution to their problems after all. There's nothing. There's no mechanism for them to turn back. Do they risk being charged with a criminal offence? Because obviously they, you know, their solemn declaration was a lie. You know, there is absolutely nothing about it. And I mean, that's not down to ignorance, because detransitioners have been known about for years. Kira Bell's case, High Court, it was, the details were broadcast around the world. The Scottish Government are well aware of it, but there's zero mention. Again, it just shows they're driven by ideology and not reality.
Yeah, exactly. Thank you for that. That was very interesting, Carol, and thank you for the contributors. I'm going to come on to a few final questions if we have any, but I'd really like to flag up the fact that Commonweal have got a really, really good thing going. It's called Learn How to Campaign. And it actually looks fascinating. How to build a campaign, what is a campaign, getting your nerve up, know your goals, build a strategy. So yeah, I'm a big fan of Commonweal, I must admit. But politics are very local as well as very national in Scottish independence. There's so many things happening. I could speak about them in Aberdeen in particular, but I won't drone on. But just please tune into Commonweal and that training stuff. It sounds really good. Any other questions? Got any more? Scotland is the home of the Enlightenment, where science and rationality originated. And we thought you had a question on that, or rights or science or anything.
I didn't have a question. I just couldn't hear what was going on.
Oh, okay, I get you now.
I was resting my concerns. So,
Okie dokie. Well, folk are beginning to tail off.
okay.
So what I'd like to do is thank our three speakers, Mark, Amanda,
welcome,
and Carol. If anybody wants any information on the talks, just get in touch with Brian or David, and you can have transcripts or more information or anything. But I'd just like to thank everybody tonight for coming along.
You're welcome, and thank you.